Hello folks. Now in this video we will be discussing your polity and governance current affairs. Good evening class. So the topics of discussion for today will be Central Vigilance Commission, euthanasia debate in India, achievements of cooperatives in India, Supreme Court verdict on DTAA double tax avoidance agreement, governor's address to the state legislature. Okay, so these are the topics that we will be discussing. Now let's start with the first one, Central Vigilance Commission. What is the Central Vigilance Commission and why has this news come into the discussion? Your President of India, okay, under the powers of Section 4 of 1 from your Central Vigilance Act of 2003. From this, the President of India, the President is able to do this because of this provision, has appointed Shri Praveen Vasishta as the Vigilance Commissioner. See, your Central Vigilance Commission means it consists of Central Vigilance Commissioner plus other Vigilance Commissioners. Okay, now using this provisions, this person has been appointed to this particular position. That is the news. So, which is why the debate is about your Central Vigilance Commission. What is a CVC or Central Vigilance Commission? It is a statutory vigilance body. Understand this. Statutory means something that is created or through it is getting its powers from an act of parliament. Okay, it is getting its act or powers through your powers of parliament, and do not confuse it for your other version when they tell it is a constitutional body. Understanding, it is not a constitutional body, it is getting its powers through your statutory provisions. What does it do? In simpler sense, it looks into anti-corruption in central government. If you see about your Central Vigilance Commission, the concept of this separate dedicated body, okay, to look into the corruption in public works, let's say with respect to your government jobs. In here, more specific to your central government jobs. This idea was proposed by your Santanam Committee in 1964. Initially, when it was created, it was a non-statutory body. The body was created based on the Santanam Committee recommendations. Eventually in 1998, they gave it a statutory recognition through an ordinance. Ordinance means what? Something that your executive passes or temporary law making procedure for your executive. An ordinance can be passed by your president on the aid and advice of COM. Then finally, it became a more formalized and pronounced statutory through the CVC Act, Central Vigilance Act of 2003. So, for CVC, the original act is your CVC Act. According to this act, we will have one Central Vigilance Commissioner and up to 2 Vigilance Commissioners. Okay, up to 2 Vigilance Commissioner means maximum is 2. Within that you can have any amount. Next, how will be the appointment of your Central Vigilance Commission? Central Vigilance Commission and its commissioners will be appointed by the President of India based on the recommendation of one committee. That committee will comprise of Prime Minister, who will be the chairman of the committee, a Union Home Minister or a Cabinet Minister who will be held by your Prime Minister, okay, and then there will be leader of opposition of Lok Sabha. The term of your CVC or VC is 4 years or 65 years or whichever is earlier. Now, first and foremost, I told you do not get it confused, your Central Vigilance Commission. with a constitutional body is because of the provisions that Central Vigilance Commission has. What provisions are there with Central Vigilance Commission, a statutory body, that you might confuse it to constitutional body? See, one of the main thing about a constitutional body, if I tell, it is mainly, firstly, let's say security of term. Yes, and salary will be charged on the Consolidated Fund of India. Yes, and also this cannot be changed. Due to disadvantage. That is, after you appoint someone, you cannot change the provisions because they are not acting how you are doing. So what are the independent and safeguards? This is for a constitutional body, I'm telling. Now I will discuss it for CVC. Now you compare why it becomes easier to get confused. The salary of your CVC, that is Central Vigilance Commissioner, will be the same as that of how much your UPSC chairman receives. The salary of your let's say Vigilance Commissioner will be the same as the salary that a UPSC member will receive. The service conditions, salary, etc. cannot be changed to a disadvantage, and also all these charges of salary, allowances, etc. are charged on the Consolidated Fund of India, which means they are not subject to parliamentary vote. Even though this is a statutory body, the respective aspects which are there for performing as an independent body, okay, whatever is needed to be called as an independent body, you are giving this body. Understanding? So these are the provisions it has. Now, if you see the removal, one more thing also with regarding to your constitutional bodies is there cannot be arbitrary removal. It has to be based on certain grounds. The removal is by President on the grounds of insolvency, moral turpitude, paid employment outside the government, infirmity, unsound body and mind, and conflict of interest. On these grounds, President can remove him. Now, if it is on the grounds of proved misbehavior or incapacity, then a Supreme Court inquiry will be done. Then if Supreme Court tells yes, advises the removal of your CVC or VC, then they will be removed based on your Supreme Court advice. Understanding? What are the core functions of your Central Vigilance Commission? If you see, first and foremost, it will inquire for Prevention of Corruption Act of 1988. That is, it will look into corruption cases, which comes under Prevention of Corruption Act, PCA Act. Next is, it will take superintendence over CBI corruption cases. Now, when we tell it will take superintendence over CBI, it will be only in corruption cases, something related to a central government. That is why your Vigilance Commission is also there. Look at this. Next is, it will review the CBI investigations, which means it also plays important role and link with your CBI and Lokpal Lokayukta also. What that is, I'll tell later. And one more important thing your CVC does is whistleblower protection, which means whistleblowers are the ones who will expose the corruption, let's say in a particular department. So these people are the ones who are given the aspect of collecting the information, trying to maintain protection of the whistleblowers, okay, under your Whistleblower Protection Act. Next is, it advises on vigilance and prosecution sanctions with regarding to your central government. And it will also be looking into your notified authority under PMLA Act of 2002, Prevention of Money Laundering Act. It will be watchful about the transactions also that keeps happening above a particular amount of limit. Next, after your Lokpal Act, that is 2013, Lokpal became an ombudsman body to look into corruption. Now, if you say there are many bodies to look into your corruption, for example, there is your CVC, Central Vigilance Commission, there will also come your CBI. Then will also come your Lokpal, after your Lokpal and Lokayukta, after your 2013. So what is the role of your CVC after the coming in of Lokpal? First and foremost, the preliminary inquiries which and all are needed. Let's say Lokpal pe a complaint is filed. It can use CVC to do the preliminary inquiry for Lokpal. Understanding? Okay, even though complaint is received by Lokpal, it can ask CVC to do the preliminary inquiry from your CVC. And this covers everyone from group A to group D employees. And also, CVC is being given one more important work. Okay, that is with regarding to appointments. It has to recommend appointments with respect to your CBI and Directorate of E-Enforcement. Understanding? So these are additional roles that CVC has got after your Lokpal and Lokayukta has come in. Next, what is the jurisdiction of your CVC? CVC is All India Services, that is your IAS, IPS, IFS who are on central deputation, and also Group A officers and also senior officers who are in your PSBs, public sector banks, RBI, NABARD, PSUs, insurance companies. Okay, so everything and anything about your central level employment or central government employment. Now, what are the powers of your Central Vigilance Commission? See, with regarding to, like previous pay I told you, under Lokpal and Lokayukta Act, your Central Vigilance Commission has the powers similar to that, that is preliminary inquiry can be done. Whatever Lokpal gets, it can send it to your CVC, which means for doing preliminary investigation, you should be able to call your officials, ask for data, records, everything, which means your CVC has the powers of that of a civil court. Understanding? It has the powers of a civil court. It can advise with regarding to your binding in practice, or with, let's say, in aspect of the cases, the preliminary inquiry, what it does will act as the base level for your Lokpal, and also it submits its annual report to the president, which will be tabled in front of parliament with the you have to place as to what are the let's say actions taken along with an explanations. Now this will be tabled by the president in parliament. And if you see your vigilance, Central Vigilance Commission, now we have in central government, if you tell there are various departments in the central government. Yes, now in these various departments, you have to know where and all corruption are happening. Means vigilance as a body somewhere it has to be present. So for that reason, we have a vigilance network, which means in every department, that is in every ministry, we will have someone called as Central Vigilance Officer or CVO who will be present. He will act as a link between that particular department or ministry, between your CVC and your CBI, to look into the cases of your corruption. Now, let's look into a possible prelims question from this particular topic. With reference to the Central Vigilance Commission, consider the following statements. First statement. The Central Vigilance Commission is a constitutional body established under the Constitution of India. This is what I kept reminding you. It is not a constitutional body, it is a statutory body. So this option is wrong. Second statement. The expenses of the Central Vigilance Commission are charged upon the Consolidated Fund of India. When I was explaining, I told you there are certain similarities between your CVC and a constitutional body. One is also your service, tenure and money. Next is the Central Vigilance Commission exercises superintendence over CBI only in corruption related cases. Now usually if you see the word only, you will be alarmed, oh maybe that statement is wrong. No, see here we discussed CVC will exercise superintendence over CBI, Okay, it can't exercise it over any of the criminal cases. The body is there only for corruption of central government employees. So, only in corruption related cases only it can exercise superintendence. So, this statement is correct. Next, fourth one. The Central Vigilance Commission submits its annual report to the Parliament through the Prime Minister's office. No, it is not through Prime Minister's office. It is through President. The report is given to the President. The President then tables it in the Parliament. So, this statement is wrong. The correct options are 2 and 3 only. Okay. Next topic is euthanasia debate in India. Okay. Now, first and foremost, why is this topic in news? Euthanasia is not a very new topic in India. It has been there since very long. All this issue, okay, is revolving around this one particular case. Harish Rana versus Union of India case, which the Supreme Court is still hearing. What here has happened means, Harish Rana versus Union of India case, they have made a plea for passive euthanasia. What it is, what are the types of euthanasia, what euthanasia is, we will see ahead. So, they have made a plea for passive euthanasia. First and foremost, let us now discuss the question, what is euthanasia? Which means you are willing to, in this case again there are multiple aspects we will discuss in detail. A person feels the ending of life is necessary in order to not be able to bear from the unbearable pain, terminal illness, etc. In euthanasia, there are two types: active euthanasia, passive euthanasia. Active euthanasia means you will use some sort of your lethal injections is administered to a person and that kills a person. Passive euthanasia means you will stop providing treatment further. Understanding? Active euthanasia pe you are injecting lethal doses. Okay, that ends the life of a person. Passive euthanasia pe you are just reducing or stopping the treatment. Eventually that person passes away. Now in India, if you see, active euthanasia is not recognized. Understanding? But passive euthanasia is recognized under strict legal norms. Now the case that we are speaking about in Harish Rana versus Union of India cases, this particular person, okay, 13 plus years ago he had fallen from a 4th floor, and because of that he sustained major injuries, so much so that he is 100% quadriplegic, which means there is complete paralysis in all 4 limbs, which means hands, legs, everything is completely paralyzed. And he has been bedridden for 13 plus years. Now they are feeling like we will withdraw the life sustaining treatment. That is, they are asking we will go for passive euthanasia. Understanding? This is the question in topic. That is why we are discussing euthanasia. Clear? No. What exactly is euthanasia? Intentional hastening of death. Why? So that you will get a relief from this incurable suffering or terminal illness. Understanding? Because of that. Now, if you see, there are a lot of aspects. Euthanasia does not mean a question of yes or no, so you will feel like you can do or not. There are a large amount of aspects involved in it. For example, let's say medical aspects. You have to be 100% sure as to, let's say, Indian psychiatrists have to know that whether a person is telling they want to opt for passive euthanasia is because of guilt, or because they're suffering from depression, or what exactly is the reason. They have to identify that. That yet is not completely full-fledgedly organized in India. Next is ethical perspectives. Now, when you see from the concept of religious, spiritual, or basic natural rights, or the concept of whole point of right to life itself, okay, is a separate component where taking away the life will also involve a lot of system of beliefs where, be it your Western, Eastern, or whichever developed, developing, least developed you are, core formative is life. It goes against that. It goes against that means it questions the roots of those, and in which way if you do is it correct, which way if you do it is wrong. That is where we will introduce the topic of right to die, right to die with dignity. Both concepts are there. Right to die is not recognized, right to death with dignity is recognized. What that is, further we will be discussing, and also there are a lot of various legal aspects and human rights issues involved in this. So there are two types of euthanasia. One is active euthanasia and one is passive euthanasia. What is active euthanasia? You will directly lethal injection being injected into a person which will take away the life form. This is a direct act. Because of your doing, that life is now gone. Reasons can be different, okay, but you are injecting a lethal dose. Next is passive euthanasia. You are not giving anything to kill a person, but you are going to withhold or withdraw the treatment. And this comes with, in India, it is with strict legal safeguards. Now, this euthanasia you have to do means that has to come with the concept of consent. Voluntary consent means the patient themselves are telling, do this. Okay, I want to opt for your passive or active euthanasia. Now, let's say a person is in vegetative state or the person is no longer able to give consent for themselves. Then comes non-voluntary. Okay, non-voluntary consent means instead of the patient, someone related to the patient will be the one who will giving. Then is involuntary. Here it is legal. Okay. But in the next concept of involuntary, it is neither with the consent nor is it legal. Understanding? That is wrong in many aspects, or it invokes questions on various dimensions. Next, let's see what are the legal frameworks we have with regarding to this topic. What are the legal framework in India with regard to euthanasia? Active euthanasia is prohibited. We will not allow that. It is not recognized. And also, according to BNS 2023, Section 100 claims it as culpable homicide, Section 101 murder, and also Section 108 is abetment of suicide. But whereas passive euthanasia is recognized and permitted by your Supreme Court in order to respect for your Article 21, it is right to life with dignity. Understanding? So, active euthanasia is prohibited and passive euthanasia is permitted. Now, few key important judgments with regarding to euthanasia if you have to see. First one is Maruti Shirprati Dubal case of 1987, where they said right to die is included in Article 21. But one important concept you have to understand from Gyan Kaur case also is Article 21 is what? Right to life. Yes. Under this, they are also recognizing something called as, this was according to your High Court observations. Okay. Under Article 21, right to life also means they are telling right to death with dignity. Okay, right to death with dignity will come under Article 21, but this does not mean right to die. Understanding, right to die is not coming under Article 21, right to death with dignity is coming under Article 21 is what is being recognized. In Aruna Shanbhag in 2011 case, passive euthanasia was allowed with safeguards, and in Common Cause 2018 they said that right to die with dignity, living wills are recognized. Living wills means when a person, that is, it is a more futuristic, okay, that a person can himself or herself make the declaration, if so and so happens, this can be done. Understanding? So this living wills are also recognized in order to perform euthanasia. Understanding? Now, in 2018, okay, now we have told that active euthanasia is prohibited, passive euthanasia is permitted. So largely this was also based on your Supreme Court guidelines also, but your Supreme Court had created certain guidelines as to what can be done with respect to your, let's say, passive euthanasia. Okay, so in 2018, okay, in 2018, Supreme Court gave a directive. That is, for passive euthanasia, we will follow these things. Alright, what is this means? It formed two boards. It allowed the provision of two boards. What is it? First board will be called as Primary Medical Board. Understanding? Primary Medical Board will be formed by the hospital. Understanding? Now, what will be there under this Primary Medical Board means the head of the treating department will form this committee. Understanding? In Primary Medical Board, where at least minimum 3 specialists will be there. Okay, based on your various aspects such as nephrology, oncology, cardiology, belonging to different departments. And also they should have had each specific person. This is at least, okay, at least 3 specialists from different departments. Again, oncology, cardiology, nephrology, different nerves, heart, all those things, bones. And these people should have at least minimum 20 years experience, each of these doctors. Understanding? So this will be the Primary Medical Board. Understanding? Now the second board is Secondary Medical Board. Clear? Now if you see who will do this means it will be constituted by district collector. The district collector will be the one who will create this, and also this will be headed by your chief district medical officer. Okay, and he will have 3 expert doctors also with him with the same medical experience. So here also 3 expert doctors. Look into this. (2018) पे Supreme Court, it again, active euthanasia, passive euthanasia not recognized, not permitted, it is more of prohibited, passive euthanasia permitted, but for that particular conditions are there. What are the conditions? You have to form medical boards, 2 medical boards. What are those? Primary medical board, secondary medical board. Primary medical board will be formed by the hospital itself, who it will be formed by head of the treating department, wherein at least 3 specialists should be there from different departments, oncology, nephrology, cardiology, etc. And each doctor should be at least having minimum 20 years experience. Second one is secondary medical board, which will be constituted by the district collector in the district, and this will be headed by the chief medical officer, and there will be at least 3 expert doctors. So in this we are getting a holistic view is what they felt. But then in 2023, Supreme Court went ahead and simplified the framework which was given in 2018. Okay, this simplification was for the 2018 framework. What does this mean? Which means, see, we will now continue with the 2 boards. Which are the 2 boards? Primary medical board, secondary medical board. But some changes are brought about. Let's say in primary medical board, what was the change brought about? Means here instead of minimum 20 years experience, I will reduce the experience to just 5 years. Understanding? And the board is reduced to 3 members each. Clear? And also one important aspect was it told that the chief medical officer, that is in this case, okay, the chief district medical officer will automatically be the chairman. And one more option, that is one more framework, is they have to give their view within a 48-hour time limit. So this was the original framework 2023 they simplified the changes for both and also gave the obligation to give their response in 48-hour limit. Understanding? So this is the procedure we have for passive euthanasia. Now if you see what are the arguments for and against to do your passive euthanasia or euthanasia in general, first and foremost arguments in favor of euthanasia is it is the autonomy of the patient, and Article 21 suggests dignity, so the right to die with dignity also is an important attribute under that. And this will give them relief from unbearable suffering of pain or terminal illness, and also it will avoid futile treatment. When nothing is going to recover and nothing is changing, then it is just costing. And with respect to utilitarian ethics according to Bentham and libertarian autonomy according to J.S. Mill, you have to more of respect the autonomy of an individual. Next, what are the arguments against euthanasia? If you see, sanctity of life, that is the core concept of, irrespective of your economic status, irrespective of you, the concept of life is involved, which will go against majority of the belief systems. And also it is a slippery slope risk when we tell many a times patients will be made to feel guilty of not opting it, or made guilty to choose it, understanding, or coerced to do it. And also this puts the vulnerable groups and assessment of the challenges, whether are they depressed or are they being forced, psychiatrist evaluation for a full-fledged, see, still mental health as a concept is not completely reached throughout, understanding. So assessment of that also becomes difficult, and also the ambiguity in BNS as to, yes, we will choose this active euthanasia in these particular parts as abetment to suicide, and all this is there. And also procedural complexities. It is not as easy as it is to take away a life. Now if you see with respect to the legal positioning, okay, which means what types of euthanasia is carried out where. Active plus assisted euthanasia is carried out in countries like Netherlands, Belgium, Canada, Australia. Assisted in suicide only is your Switzerland. Passive euthanasia is followed in France and Sweden, and in Italy they have the right to refuse treatment. We'll see one possible question on this. With reference to euthanasia in India, consider the following statements. First one, active euthanasia is permitted in India under judicial supervision. Active euthanasia permitted in India is not there. Simple word is, it should either be active euthanasia is not permitted in India, or instead of active euthanasia it has to be passive euthanasia is permitted in India under judicial supervision. So first statement is wrong. Second statement, Passive euthanasia has been recognized by Supreme Court and as a part of right to life with dignity under Article 21. Correct. Third statement. A living will allows a competent person to refuse life-sustaining treatment in the future. Like we told, living will is recognized. This statement is correct. Next statement. The Bharatiya Nyaya Sanhita 2023 decriminalizes abetment of suicide in cases of terminal illness. No, it criminalizes. So this is not correct. Correct options are 2 and 3 only. Next topic is achievements of cooperatives in India. Why is it in news? See, United Nations has declared 2025 as the year of cooperatives, and also the theme was cooperatives build a better world. So it is more of international recognition of India's cooperative model. Now, if you see the whole concept of cooperatives in India, it is built on the concept of your Vasudev Kutumbakam, which means world is one family, or Sahakar se Samriddhi, prosperity through cooperation, and also it focuses on collective welfare, community-led growth, and all this will speak about your inclusive development. It also aligns with holistic development, and this will be one step closer towards us realizing at Vikshit Bharat at 2047, developed India by 2047. Now, if you see the cooperatives in India, how far or how well they have fared, first and foremost, as of now, there are 8.5 lakh plus cooperatives. 32 crore members are registered, and 98% of rural India is covered under your cooperatives concept. And their presence is there in more than 30 sectors, and also 10 crore women are linked to your self-help groups. Now, if you see with respect to national level cooperatives, we will see with respect to your NCEL, that is your cooperative exports, okay, that is, and also one more thing is your NCOL, organic products or Bharat Organics, so almost 30 different products are sold under your tag of Bharat Organics. And last is your seed distribution through your Bharat Beej. Understanding? Now, if you see, first and foremost with regarding to your cooperatives, let's say I will now be telling BBSSL. What does it stand for? Means you can write down Bharatiya Beej Sahakari Samiti Limited. Bharatiya Beej Sahakari Samiti Limited. Okay. What does it do? It distributes Bharat Beej seeds, which is affordable, certified, quality seeds. Understanding? And also, if you see, because of these aspects, your cooperatives no longer be seen as something that has to be brought in about change only in developing countries or only in least developed countries. This is a holistic model which tries to showcase about your entrepreneurship drives if you also bring in. Now, when we tell with respect to your MSME sectors, understanding, cooperatives play a huge role, and also one of the important thing your United Nations will keep telling is the absence of women, okay, in your employment is creating huge amount of loss. That also this helps bridging the gap. Now, one more thing if you see is with respect to your National Cooperation Development Corporation has held that now your NCDC will disperse 95,000 plus crores annually with regarding to your cooperatives, and also special boost impetus is received through your dedicated Ministry of Cooperation. Understanding? So this offers your financial support, that offers your systematic growth of Ministry of Cooperation. So let's see what are some of the initiatives and achievements with regarding to your cooperatives. First is we have a holistic roadmap for the decadal growth. That is not just in 5 years or 6 years, but every 10 years if you say, that is from your 2025 to 2045. We have a National Cooperation Policy 2025 which gives a clear outlook. Now see, when I told you it aligns with our Viksit Bharat 2047, this helps in doing that. Next is there has been a huge amount of growth with respect to dairies and fisheries. Like I told, 30 plus sectors we are seeing cooperation. One largely is your dairies and fisheries, trying to create white revolution 2.0. And also new dairy cooperatives are being added, the 20,000 plus are added. Another thing is your fish farmer producer organizations are also increasing. Next is financial inclusion. RuPay Kisan credit card, or in otherwise, these are which provide loans to your farmers. Understanding? To more than 22 lakh Kisan cards has been disbursed and 10,000 plus crore loans has been given as of now. And also with respect to your market and exports also, it is linked to see from the beginning to the ending, which means your NCOL, National Cooperative Organic Limiteds, and BBSL, Bharatiya Beej Sahakari Samiti Limited, are also brought in order to support the cooperatives at various stages. And if you see with respect to the infrastructure also, we are moving towards creating the world's largest decentralized grain storage plan, wherein we are planning of storing 68,702 metric tons capacity through your primary agricultural credit societies. And agricultural self-reliance is to be brought in, especially in your pulse and maize procurement. And most important thing is with respect to your education and innovation, where for the first time in India we have set up Tribhuvan Sahakari University in Gujarat and also Sahakar Taxi Cooperative. It is about your mobility in cooperatives. Next, let's see constitutional framework with regarding to your cooperatives. See, cooperatives gained constitutional status, especially in your 97th Constitutional Amendment Act in 2011, also under fundamental right of Article 19(1) of C, right to form associations, cooperatives. Okay. Next is your DPSP, which speaks about Article 43B is promotion of cooperatives, and it added a new part. The 97th Constitutional Amendment added a new part of your Part 9B, which is cooperatives. Part 9 Panchayat, Part 9A Municipality, Part 9B cooperatives. If you see the regulatory structure with regarding to cooperatives, if it is a state level cooperative, then it will be based on that particular state law, regulation, etc. And all of these will be looked after by your state level registrar. If it is a multi-state level cooperatives, now let's say Amul, understanding, now these kind of things, they do not just operate in one state but in multiple states. That means you need not just state laws. So in these cases we have MSCS Act of 2002, okay, which by your center. Now if you see with respect to your cooperatives, the highest number of cooperatives are there in Maharashtra. Almost 57% of all the cooperatives are in the top 5 states which have maximum number of cooperatives, which is Maharashtra, Gujarat, Telangana, Madhya Pradesh and Karnataka. Let's see one possible question from this particular topic. With reference to cooperatives in India, consider the following statements. The 97th Constitutional Amendment Act 2011 introduced Part 9B to the Constitution to provide a governance framework for cooperative societies. Correct. Second statement, all cooperative societies in India are regulated exclusively by union government under Multi-State Cooperative Societies Act. See, look at this. All cooperatives in India are regulated under exclusively. No, the state cooperatives will be through state laws. Only your multi-state, more than one state, will be through your Multi-State Cooperatives Act. So this statement is wrong. Next statement. The National Cooperative Development Corporation NCDC provides financial assistance to cooperatives across multiple sectors. This is correct. 95,000 plus crores has been given. Next, fourth statement. Article 43B of Constitution directs state to promote cooperative societies as a part of DPSP. This is also correct. So the correct options are 1, 3 and 4 only. Next topic is Supreme Court's verdict on DTAA. Why is this in news? First and foremost, let's take this issue. In simpler sense, first I will tell it to you, then I will tell you what is the issue lying behind it. So what happened was, your Tiger Global, okay, who are they? Means they're considered like a venture capital. Now these people had sold 1.6 billion stakes, that is sale, in Flipkart to Walmart. Understanding? Now your Supreme Court has held that no, you will not be given the benefit of DTAA. Now this brings us the question, what is your DTAA? Double Tax Avoidance Agreement. This is not given to you even though it comes under your India-Mauritius DTAA. And we are going to remove this benefit and invoke GAAR, which indicates that we will give importance to substance over form. What does all of this means? Okay, let me explain it in the most simpler way possible. Listen to this, I'll tell it to you like a story. This is India. This is Mauritius. Okay, let's say a person from Mauritius, okay, he is residing here, but he invests here, okay, and he keeps making money basically in India. So now what happens is, because if this particular person is now investing, making profit or doing business, let's say that, now if you just see, he is here, so he has to pay tax. He is working here, so he has to pay tax. So you have paying 2 tax. So this will not be beneficial for the person. So under DTAA, what you are doing means, you don't have to pay tax in both countries. You can just pay tax here, and here it will be 0 tax. Or otherwise, you pay tax here, that will be returned back here to you. Okay, this is your DTA. But now what has happened means, many companies, many investors, especially they will go for things such as policy shopping, or basically they will try to create a false line, which means their whole objective is for evasion of tax or non-payment of tax. You will find out all the possible loopholes through your shell companies. Okay, you will create shell companies, you will create in such a way that, okay, you are not operating from there, but you will tell, it is from here, just so that you will create the paperwork in order to avoid payment of the taxation to the government. In that case, when people's objective here is not just this was a honest thing where, okay, a person doesn't have to pay tax both ways. But in these cases, your objective itself is only to evade taxes. In those point of time, we are telling DTAA, Supreme Court has told DTAA will not work. Instead, GAAR will work, which means your whole point is general tax avoidance is your whole objective. For you, this exemption should not be given. Now, you may tell, yes, this particular Tiger Global, this was done through, yes, telling Mauritius, etc. But if you see, Supreme Court has held that the head and the brain was outside Mauritius. It was primarily in USA. First thing. Second thing, for you to claim DTA, that entity should have been owned by Mauritius. In this case, that is also not the scenario. Then which means for you, for your Tiger Global, this will not be applicable. This will be applicable. Which means instead of just mere legality on paper, instead of the form, we will prefer the substance. What is the objective? We are not going to blindly tell, here I am going to give you one residence certificate of where do I reside. Based on that, I am not going to accept and give you DTAA. Understanding? This is your whole news of your Tiger Global or otherwise DTA. Look into this. Your investor Tiger Global, who's a venture capitalist, had made a transaction sale of Flipkart to Walmart. This amounted 1.6 billion. The issue came is capital gains tax had to be paid. Now they claim DTA. Now what happened was your Delhi High Court, your AAR first had held that no, I will not allow for you to get the exemption under DTAA, and this is where they had held over your AAR. What that is, I will tell you. This is the body that held substance over form. This was cancelled or this was squashed by Delhi High Court, which was again reversed by a Supreme Court and which held back the same thing. Understanding? Okay, this is just an example as to how this concept of DTAA works. Now, what is AAR? Authority for Advance Rulings. It is a quasi-judicial body. Why is it there? In order to give tax rulings so that it reduces uncertainty and litigations. Now, if you see with regarding to your Supreme Court's findings on this case, they have held that TRC is not conclusive for your DTAA benefits. Just because residence, you are telling I am in Mauritius, so technically DTAA is signed with India and Mauritius, I should not be made to pay tax. In this, they tell that, see, you are just giving me one residence certificate telling you are from Mauritius. But if you see, the head and brain is not even there. It is outside Mauritius. It is happening in USA primarily. And also, your objective here is only to evade tax. So, here I will hold substance over form. Okay. DTAA applies if direct ownership is through Mauritian entity. Here, that was not the case. It was a US entity. And it focuses on economic substance. And it applied control, management, head and location brain. Who is controlling the entity? Who manages the entity? Where was the head and brain? That is the majority of idea, the majority of these things which took place was the idea, etc. from your US. So that is not applicable. So this entity is managed in US and not in Mauritius. So thus you are not applicable to your DTAA claims. And also they have held that your AAR also held the same thing. Grandfathering under India is not allowed, which means you will protect the investors for anything that happened before 1st April 2017, and capital gains taxable only in Mauritius and it will be 0% in India, which means anything, if you are, like I told you, you are living there and also your business is here, then you have to pay tax there, don't have to pay here. So one only, you don't have to pay two. So Supreme Court also held the same thing that your AAR also held. Grandfathering is not automatic and this will be denied where the whole objective is just for tax avoidance. This is where AAR also held substance over form. Supreme Court also held the same thing. So what is your DTAA? It is bilateral treaty between, in this case, India and Mauritius to avoid double taxation. Here you will see as residence country and source country, where you are residing, where your income is getting generated. The relief methods are exemption method, you don't have to pay tax in one place, or other thing is credit method, that will be given back to you. In Indian context, we have 90 plus DTAS, and TRC is mandatory but not sufficient. Just because you are residing there doesn't mean that that is the sole point of taking into consideration. The misuse is usually petty shopping. Your objective is to avoid paying tax, round tripping, the creation of shell entities, understanding. What is GAAR? General Anti-Avoidance Rule. What is this? This has been effective from April 1st, 2017. It is an anti-tax avoidance tool, where there'll be many sections which are there only to avoid tax. That will be avoided from this. Okay. And the consequences are denial of DTAA benefits, and also they will make sure that your tax plus interest plus penalties, all of those are paid. This is also over the fact that you will not trigger, if any of these conditions happens, okay, then this will trigger your GAAR. We'll see one possible prelims question from this topic. With reference to recent Supreme Court verdict on double taxation avoidance agreement, consider the following statement. First statement, possession of valid tax residency certificate automatically entitles an investor to claim DTAA benefits in India. Like we told, TRC is mandatory but not the sole aspect which will be used in your DTAA benefits. So, this statement is wrong. TRC provision doesn't automatically mean DTAA benefits. Second statement, under Indian law, the general anti-avoidance rule can override the provisions of a tax treaty. Yes. Third statement, the India-Mauritius DTAA provided grandfathering benefits for capital gains arising from investments made before 1st April 2017. Correct. Next, GAR applies only if an arrangement fails all the tests prescribing under income tax simultaneously. No, only one. So, the correct answer is 2 and 3 only. Next, last topic of the day is Governor's address to the state legislature. In simpler terms, what has happened means your Karnataka state, that is your executive, and your Karnataka governor, also part of your state executive, have come into head-on heads with each other. Meaning what? So your governor is to address the state legislature 2 times. Okay, one is at the beginning of every financial year and also after your general elections. Now, when he is going to address the state legislature, he has to read, right, a particular speech which will be given by the COM to the governor. Now, the governor, what he can do is, let's say there are some portions of it which is, let's say, too critical of certain things. He can tell the COM to reconsider it or think about it, seek clarifications on it. But in this case, what happened was Karnataka governor prohibited some portions, okay, of the speech which was more of critical of your central government. So this has brought in the debate as to can governor single-handedly on his own discretion omit parts of the speech. Okay. So Karnataka governor and state government have come in head on head. Why? Because deletion or modification, that is he did not use about certain portion of government's address which gave reference especially to your union government policies of Manrega fund delays, and the same concepts has been witnessed in both your Tamil Nadu and Kerala also among the state governments and governor. So this brings us to the question of impartiality, or your governor, is he acting as a bridge or is he acting as a barrier? So bridge versus barrier questions has brought us to this topic. So what exactly is a governor's address? It is a constitutional formality where he has to address the legislature first session after every general election and first session of every year. Now your February is coming, your financial year will begin. So what he has to speak is not what his personal views are, or Raj Bhavan's discretion is not something that you will exercise here, but rather it will reflect the policies and programs of the state government, and this will be prepared and approved by the Council of Ministers. Now if let's see constitutional provisions, most importantly Article 176, which speaks about governor's aspect of addressing the state legislature, constitutional formality, and Article 163, which says that governor will act on the aid and advice of Council of Minister, and Article 168, which is about composition of your state legislature, and Article 175 of 2, governor may send messages to the house on ministerial advice. Okay. Now let's see a few of the judicial interpretations with regard to the powers of governor. Euthanasia. Okay, online class, live pay, you have asked me what is euthanasia. Again, like we mentioned, it is an act of a person, okay, hastening death. That is, you are telling that, okay, in case, let's put it, this person is suffering from a very bad disease or a terminal illness, and they prefer to end their life. They want to not continue with the treatment. Okay, that is euthanasia. Live class, understood? Live class, did you understand it? Okay. So let's see certain judicial interpretations with regarding to this. In your Shamsher Singh versus State of Punjab case, governor is a constitutional head and not an independent executive authority. In Nabam Rabia case of 2016, it held that governor cannot act without or contrary to the ministerial advice, otherwise your COM's advice, except on topics where you have constitutional discretion. Now here the veto power of governor over content of address is not there because that doesn't come under your constitutional discretion. Now the main question is, can governor refuse to read the address or he himself delete or modify the COM approved content? Okay. For that, first and foremost, see, governor cannot alter the substance. Okay, which means he cannot modify the report, he cannot delete parts of the report that he feels is not correct. And what he can do is, he can suggest changes or seek clarifications, but he on his own unilaterally cannot change the decision. Ultimate decision lies with the COM or your elected government. So this has brought us to the question of your bridge versus barrier. Otherwise, is governor office an impartial office or is it favoring only the center? If you see with respect to commissions by your Panchi Commission or Sarkaria Commission, what they have told on the office of governor means, Panchi Commission has held that it has warned against partisan misuse of your governor's office, and Sarkaria Commission has held the same thing that we have been discussing. Governor should be a bridge and not a barrier between central government and state government, because otherwise this is creating a conflict in the cooperative federalism. Understanding? Now, let's see a possible prelims question on this. With reference to the governor's address to the state legislature, consider the following statement. The governor addresses the state legislature at the first session after general election and first session of every year, 2 times. Yes. Second statement. The content of the governor's address reflects the personal views and discretion of the governor. No, this is not supposed to reflect. Okay. This is not supposed to reflect your personal views and discretion of governor. Next statement is, The governor can unilaterally delete or modify portions of the address approved by the Council of Ministers. He cannot. Here instead of can, if cannot was there, this would have been correct, but this statement is wrong. He cannot do that. Ultimate decision lies with the elected government. Last statement. The governor is required to act on the aid and advice of Council of Ministers while delivering the address. Correct. He has to act on the aid and advice of COM. The correct options are 1 and 4 only. Understanding? With this, we are at the end of the content. Okay. Online class. Any doubts? Live session. I have clarified your doubt. Okay then. Any doubts? Let's end the session then.